My name is Liz Davies. I'm one of the barristers in the Court of Protection team here at Garden Court. We have you in the room. Hello, it's nice to see you. And what we can't see is there are about, forgive me for worrying you, 370 people watching remotely. So we're into attendance of 400. So thank you very much for that. We're absolutely delighted that our panel of Garden Court barristers have been joined by District Judge Anselm Eldergill. He's familiar, I think, to certainly everybody in the room. I'm sure everybody watching remotely as well, as the District Judge in the Court of Protection for 14 years between 2010 and retiring earlier this year in the summer. So he's overseen in the Court of Protection the development of the Doles regime, filling the Bournemouth gap, etc. Many of us have appeared in front of him. He came to the judiciary from a background of mental health law, including serving as president of the Mental Health Lawyers Association and also president of the Institute of Mental Health Act practitioners. But those of us who appear in the Court of Protection in front of him know him not just as a conscientious judge, which you'd expect from every judge in the Court of Protection, but somebody who is deeply sympathetic to P and also has a deep understanding of the Mental Capacity Act, the Court of Protection, the procedure and the legal framework. And he may have come off the bench, but his plan is to return to legal practice as a consultant next year. And most importantly, his book on the European Court of Human Rights and Mental Health is going to be published in about 3 weeks' time, the 17th of October. So do have a good look at the flyer. And I've had the advantage of reading his presentation in advance, and I can tell you he covers both mental capacity and mental health issues, including the relatively new Schedule AA1, but has some really thoughtful and indeed philosophical observations on Doles and observations on the strengths and weaknesses of the current legal framework and what we might expect from the future. District Judge Eldergill will wrap up the seminar. We will start with some, if you don't mind me saying this, more nuts and bolts review of case law, and two excellent Garden Court barristers, Acland Bryant, on my far left, joined us about 6 months ago, and he's very much a rising star. He's going to blush now in the world of court of protection litigation and also environmental litigation, joining us from Friends of the Earth. And his presentation is an overview of recent case law on the inherent jurisdiction, on covert medication, and European Court of Human Rights consideration of personal autonomy within an Article 8 framework. And he'll then be followed by Felicity Williams, immediately on my left, who is a specialist in court protection work, along with public law and community care. And her presentation is on best interests, specifically around risk, safety and happiness, and the capacity to enter into sexual relations, and also on transparency issues. You see a very much focus on the autonomy of P and when it comes to personal welfare, best interest decisions. I do need to do a bit of housekeeping. For those of you who are in the room, please make sure that your mobile phones are either switched off or on silent. For those of you who are watching remotely, please be on mute. I have been in webinars where somebody had a rather embarrassing row with her husband. It was a little bit of a shock for everybody else. A member of the audience, I should say, not the speaker. So if you're going to have a row with your nearest and dearest, do it with mute on, please. I have to make the usual fire safety announcement. If there is the fire alarm, we're not expecting a drill, so it will be the real thing. Please follow the fire exit signs to the nearest exit, which are down the main staircase that you came up and out the main door, and walk to the assembly point, which is across the road by the gates to Lincoln's Inn Fields. All the doors automatically release if the fire bell rings. The easy way is if you follow the Garden Court speakers, they'll be first down the staircase, so just follow them. We have toilets. The women's toilet is just there. The men's toilet, if you go out towards the staircase, it's on the other side of the landing. And downstairs we have a gender neutral toilet. The event is being recorded and live streamed, and the recording will be uploaded to our YouTube channel. And we will send all attendees both the link and the slides that you're about to see. We will take questions after all three speakers have finished. That's usually better than if we do it after each speaker. And if you're watching remotely, you can put questions up either on the chat or the Q&A. You'll get instructions on that. And we'll try and take some of those questions as well. And after the discussion ends, and this only applies to those of you in the room, I'm afraid, but we will be having food and drinks downstairs in our hub room. So please do join us if you can. And of course, that's another opportunity to ask any questions that you may not have you may not have wanted to ask in this environment, or may have only occurred to you as we wrap up, because our speakers will be there and you can ask more informally. And I think that's all the housekeeping that I need to do. And I've done the introduction. So on that basis, I'm going to ask Acland to start us off.
Perfect. Good evening, everyone. So I'm going to kick off tonight by first looking at a recent case considering the inherent jurisdiction. So the case is the London Borough of Hackney and others. By way of background, A, or person P, was a young man aged 22. He was considered to be habitually resident in England and Wales, but has a Spanish passport and was also likely to be a Spanish citizen. Court of protection proceedings were initiated due to significant concerns around A, or person P's mother. There were lots of different concerns around drugs and drug paraphernalia at the property, engagement with social work and social care, and concerns around person P's medication and person P going missing previously. The Court of Protection had considered that a person P lacked capacity to conduct proceedings, and ultimately where the inherent jurisdiction or this court came in was after person P had not been seen for around 16 days. The local authority applied for a collection order and an order against the telephone companies to assist with identifying where B, which is person P's mother, was, in the hopes that that would also assist in identifying where person P was. So the issue before the court, or the key issue, was the legal basis for making the orders sought, and whether the court could make the orders sought under section 16(5) of the Mental Capacity Act, or whether under the inherent jurisdiction, or both. The court's ultimate conclusion was that they could make the orders sought under section 16(5) of the Mental Capacity Act, but if the statutory provision fell short in any way, the judge held that the inherent jurisdiction could provide the necessary jurisdiction in any event. So there was a large discussion by the judge as to the interrelationship between section 16, the statutory basis, and also the inherent jurisdiction. I won't read absolutely everything in detail. You will get the slides afterwards. But interestingly, there was reference to the Court of Appeal judgment in Re G, and the court said that injunctions can also be made under section 16, provided the just and convenient test was met. But if that statutory scheme falls short in any way, the inherent jurisdiction can be considered. Reference was made to the case of HMPM and KH, which is a Mumby case. The court if the court is concerned with the welfare of an adult who lacks capacity, a significant range of orders can be made under the court's inherent jurisdiction against others to locate that person. There are a couple of other recent or fairly recent cases considering the inherent jurisdiction, just to give you a flavour of what those cases concern. First, in the case of Re AG, this case concerned an order being sought under the Forced Marriage Civil Protection Act to prevent the parents from forcing AG to get married and travelling abroad. BSJ considered and accepted that the court could invoke the inherent jurisdiction to make a limited term order regulating both contacts between AG and her parents and any travel. In the second case of GK and another, the court was asked, or the court was considering whether to grant an injunction under the inherent jurisdiction to prevent person P undergoing any form of gender-affirming medical treatment, and also whether the parents should succeed in their application to instruct an expert psychologist. E was a looked-after child who identified as being non-binary and was due to turn 18 later that year. The Court of Protection refused both the application for an expert assessment under the inherent jurisdiction and also the injunction. In the third case, which is a case of RE or RK, the court was concerned with person P, who was a 30-year-old person who had Down syndrome, was living in a supported living environment. The core issue in the case was contacts between person P and her parents. There had been a fallout between them. And the court, Mr. Justice Cobb, was being asked whether to make an order under the inherent jurisdiction. Mr. Justice Cobb refused to make such an order, saying that the presumption of capacity hadn't been rebutted in the case, and who refused to make an order under the inherent jurisdiction and found that there was no jurisdictional peg whatsoever in order to make the order sought. Moving on to covert medication, the recent case of RE-A is a 2024 case. Person A was a 25-year-old woman with mild learning difficulties, had an Asperger's syndrome, autism, epilepsy, and was subject to the Court of Protection proceedings for about 5 years. She was receiving specialist medical treatment and in particular hormone replacement therapy, which had been administered covertly. A didn't know that she had been through puberty, and on the balance of the hormones given to her prevented her from experiencing menstrual bleeding. She then found out that she had been through puberty, but despite that, still refused to take HRT willingly. The court was concerned primarily with the question of residence. Person P's mother was seeking the return to her care as opposed to being in a residential care setting. The court had to consider, firstly, whether there should be an ending to the covert medication, and also whether person P should move from the care or the residence that she was currently in to live with her mother. The court found that it could make a decision in A's best interest about residence and could also make a decision about covert medication. Ultimately, the decision the court came to was that it was in A's best interest to return home, for covert medication to cease, for A to be informed that she had been covertly administered HRT for the benefit of her health, and A's mother, B, should be allowed to try and persuade A to take HRT voluntarily, and for support to be given to them in the community when she was living at home. In coming to the decision, the court reviewed the existing body of case law around covert medication and said that there is not a large body of cases. They did consider also the Vice President's guidance, so that's Mr. Justice Hayden, which was outlined on the 17th of January 2020, and all the authorities and the issued guidance from the Vice President all very strongly put forward that covert medication involves a strong interference or a serious interference with a person's rights under the European Convention of Human Rights. The judge in this case said that the issue around residence is complex, it can't be divorced from A's covert medication, and there is a need for A to receive hormone treatment if at all possible. The court weighed, as it does, in the balance the positives for allowing B's application and for saying that A should return home. Key things that the judge placed emphasis on were A's strong wishes to return home, ending the deprivation of liberty, the serious infringement of A's autonomy by terminating and the need to terminate covert medication, the regulation of her contact with her mother, and restoring full respect for her family and private life. On the other side, in terms of the negative consequences, the judge placed weight on that A would be returning home without the protection and separation that can be provided. There was to an enmeshed relationship that caused significant harm in the past. It was likely to expose her to risk of harm in the future. It wouldn't be practical to administer HRT covertly, and she would be unlikely to volunteer to take HRT or voluntarily take HRT. And so there was a significant risk that the consequences of early menopause could occur. There are some other covert medication cases there. Some of them are older than others due to the lack of a significant body of case law on this particular issue. I won't go through each of them in detail, but you have the cases there, so you can go away and look them up. The last case is a recent case, and it considers the issue of autonomy. It's a case that was heard by the European Court of Human Rights, the Grand Chamber, and that is quite significant in that the Grand Chamber doesn't often decide cases, at least at times. This case concerned Ms. Pindo, who was a Jehovah's Witness living in Spain. Ms. Pindo had issued an advance directive saying that she didn't want any form of blood transfusion. On the 6th of June 2018, Ms. Pindo was admitted to a hospital with serious internal bleeding. She was then transferred to another hospital to receive specialist care. She believed that this was going to be without the need for a transfusion, although she seemed to deteriorate a lot when she was traveling to the other hospital. During the travel to the other hospital, the clinicians with her informed the hospital of where she was going, of her deteriorating state, and they called the duty judge. The duty judge then informed the prosecutor in Spain and also sought expert opinion from a medical physician as to what to do. Ultimately, the judge decided that Ms. Pindo should receive blood transfusions and that the right to life should prevail over any issues surrounding whether Ms. Pindo lacks capacity and should receive treatment. Ms. Pindo then appealed to the domestic courts. The domestic courts refused her application, and ultimately she went on to appeal to the European Court of Human Rights. The claim initially raised two grounds, or had two main features. Firstly, Article 8, and then Article 9. By the time the application was actually heard by the court, Article 9 had more or less disappeared, and the focus was on Article 8. The court decided that the decision-making process of the judge was affected by the omission of central information. The judge was unaware of the applicant's wishes that had been documented. Neither Ms. Pindo nor anyone connected with her care was aware of the decision taken by the duty judge. Neither the issue of Ms. Pindo's wishes and feelings nor the issue of her capacity to take a decision were addressed in an adequate manner. And the court also found that domestic courts failed to adequately address Ms. Pindo's complaint. Ultimately, the court found that Ms. Pindo's Article 8 convention rights had been violated, and in coming to that conclusion, they read her Article 8 rights in light of her Article 9. And ultimately, the court awarded €12,000 in compensatory damages. The court didn't make any award in respect of punitive damages. The court did take time to carefully set out the relationship between the different convention rights. Firstly, starting with Article 8, the court noted that every adult patient has the right to refuse freely and consciously medical treatment, notwithstanding the very serious, even fatal consequences that that decision might have. However, Article 8 is a qualified right, and Article 2, the right to life, will be important in a situation where there's an imminent threat to life. In an emergency, if there are reasonable grounds to doubt that the individual decision, it cannot be considered a failure to respect their personal autonomy to proceed with urgent life-saving treatment. That being said, the wishes of the patient must be treated as being paramount. There's a need for healthcare professionals to make every reasonable effort to determine what the patient would want. What constitutes reasonable effort will always depend on the circumstances and the facts of the specific case, and they will be influenced by the content of the domestic legal framework. If, despite reasonable efforts, one is unable to establish to the extent necessary that the patient's will is indeed to refuse life-saving medical treatment, the duty will always be to protect life and provide essential care. That's my presentation, so thank you very much.
A real emphasis from the courts on personal autonomy there, a theme which Felicity is going to continue.
Thank you, Liz. Thank you, Acland. Yeah, so I'm intending to deal with three themes that have arisen in cases over the last year. Firstly, I'm going to deal with the question of best interests in terms of balancing risks, considering P's safety and happiness. And then I'm going to turn to some cases specifically in the field of capacity in relation to sexual relations. Many of you will be aware that this has been an issue that's come before the courts many times over the last year. And then finally, I'm going to deal with some procedural cases concerning transparency and closed material. So turning to this first case of AB and CD, this was a case involving consolidated proceedings. First of all, there was an annual review of the continued deprivation of liberty of CD, and there was also a health and welfare application by his mother, AB. The court was seeking to determine residence and care, whether CD should continue to live at his current placement with a separate care provider, KL, or whether he should return to live with his mother, AB, who lived in the south of the country. It should be said that CD's placement was in the north. The court was also considering contact arrangements and, importantly, also the appointment of a health and welfare deputy. A key aspect of the case that the judge drew attention to was the very significant gap between AB's approach to risk and that taken by the care provider, KL. KL tended to be quite risk averse in its approach to CD's care, whereas AB believed her son shouldn't be wrapped in cotton wool and felt that he had much more life that he could be leading. The court was quite sympathetic to what Mum had to say, and in fact did find that KL had adopted a very risk-averse approach. Concern that CD had been left watching the dryer for considerable periods of time at his placement. And in contrast, AB had brought him up with a much more risk-taking approach, allowing him to think that risks are worth taking in order that CD can fly. The judge did conclude that it was in AB's best interests to remain at his placement, certainly for the year ahead, although she was keen to relax restrictions on contact, ensure that he could spend more time with his mother. And certainly looking forward into the future, the approach of the court was that it was hoped that perhaps mother's approach could be the direction of travel, and that perhaps he might not need to remain in his current circumstances beyond the year review. Interestingly, the court also took the approach of appointing the deputy as was requested, and with a view specifically to that deputy having a role in assisting both contact and communication arrangements. The court noted this is one of those rare cases in which it's in CD's best interest for a deputy to be appointed for the reasons put forward by the expert. As Ms Gardner put it in her submissions, hopefully a health and welfare deputy will draw a line in the sand because the current arrangements are not working. And the court was really seeking to bring together both sides of the equation and draw narrow the differences between KL and P's mother. Another interesting contrast to this case is the one case that I've listed there, NHS South East London ICB and AB. This was a case in front of Judge Hilda, and she'd made numerous attempts to try and ensure that a trial could be put in place to enable AD to return to live with her mother. Unfortunately, despite the case running over a very prolonged period, trials having been set up, ultimately it failed, and the court had to conclude that a trial to return home was not going to succeed in that case. The case of MA and Gateshead Council concerned a much older lady, a lady of 90 years old, MA, and the determination was about care and residence. MA had a diagnosis of dementia and was living in a care home following her discharge from hospital. In this case, she had a number of children, 4 sons and a daughter, and unfortunately those siblings were not in agreement as to the best approach in her case. On the one hand, one of her sons felt very strongly that she should remain in the care home where she was reported to be safe. On the other hand, other siblings considered that the trial placement at home should proceed because MA had always expressed a very strong wish never to be put in a care home. The court completed a very careful review of the law on best interests and looked very carefully at the balance that had to be struck between safety and happiness. The court went back to refer to Lord Justice Mumby's observations, which were set out in that case of KK, noting we must be willing to tolerate manageable or acceptable risks as the price appropriately to be paid in order to achieve some other good, in particular the vital good of the elderly or vulnerable person's happiness or dignity. And it is a judgment that's worth going back to and having a read through. So many of us deal with many of these care homes cases on a very regular basis. And it just, once again, I think brings the cases back and puts them in perspective. It's really helpful. The court was keen to underline that any proposed solution was not required to be perfect. And on a careful review of the evidence, the judge allowed a trial at home, observing that it was the least restrictive option. Jay and Luton Borough Council, very different type of case, parallel COP and family proceedings. And the issue for determination was whether it was in Jay's best interest to travel to Afghanistan. The family in 2022 had begun plans to travel to Afghanistan for Jay and his sister with the intention that they would enter into arranged marriages and visit family there. An interim forced marriage protection order was imposed after it was assessed that Jay lacked capacity to marry or engage in sexual relations. And then in July 2023, the family made an oral application for an order that Jay should be allowed to travel to Afghanistan again, and that was refused by the court. The matter came back on appeal, and it was argued that the judge had relied too heavily on risks that were set out in the Foreign and Commonwealth Development Office guidance, and not sufficiently specifically on factors relating to Jay and his family. Lord Justice Peter Jackson, in the lead judgment, noted that it was an unusual application in the Court of Protection involving a visit to a country with significant risks. And the feared risk was mainly of detention and non-return of J, who received significant levels of support in the UK. He observed that when assessing risk in cases of this nature, it's important that the fullest consideration is given to the importance of a person's heritage and family relationships, with an awareness that an unduly risk-adverse approach can itself cause harm or welfare disadvantage. However, overall, he concluded that the judge took account of everything that she was obliged to consider. He noted that there were two additional matters that the court hadn't focused on, and that was that the court had no information about why asylum had originally been granted to the family, and that Jay would have to travel on his British passport as his Afghan passport had expired, and each of those factors might add to the risk assessment that was to be carried out. So the appeal was dismissed. Turning then to the second theme I wish to speak about tonight, and that's capacity in relation to sexual relations. I'm going to talk about three specific cases that were all heard by Mr. Justice Poole, in fact, in which he developed the thinking around the assessment of capacity in relation to sexual relations. You'll see that as the cases developed, he began to pick out more complex themes. So in the first case, PN was a 34-year-old man who was living in local authority care. He was described as having significant care needs as a result of a mild learning disability and autistic spectrum disorder. Mr. Justice Poole described meeting with PN. He'd obviously taken some enjoyment in this meeting, and he noted that he was a man with a big presence and strong views, who sometimes expressed himself with conviction. PN had a somewhat troubled history. He had a history of offending behaviour. There was some offences of violence, and also some allegations around his sexual conduct. So it was quite a complex background that the judge was dealing with. PN was assessed to lack capacity to conduct proceedings, to make decisions about residents' care, contact with others, which was an important aspect, and the use of social media and the internet. The court was asked to make determinations about whether PN lacked capacity to make decisions about engagement in sexual relations, about disclosing information about the risk of sexual harm he poses to others, and about allowing the local authority to disclose information on the risk of sexual harm he poses to others. And as you will see in a moment, one concern the court had was about this stratification of decisions that the court's being asked to address. It's clear in this line of cases that Mr. Justice Poole is worried that he's being increasingly asked to address diverse questions that could possibly be subsumed under wider headings. So Mr. Justice Poole considered the Supreme Court judgment in JB and the formulation of the information relevant to the decision to engage in sexual relations that had been given by Lord Justice Baker. He noted that Lord Justice Stevens's judgment appeared to recognise that the relevant information may differ from case to case. So the relevant information will depend on P's circumstances, their sexual orientation, sexual practices and preferences, and whether there is an identifiable person or persons with whom they are likely to have sexual relations, and what the characteristics are of that person or those persons. He observed the Court of Protection must not allow the desire to protect others unduly to influence a clear-eyed assessment of P's capacity. And I'll leave you to read the rest of that paragraph, but he was very concerned that the court shouldn't step into a role of using capacity as a tool by which to protect others, and also that the Court of Protection shouldn't be being overly influenced by the criminal aspects of the case. It wasn't the role of the Court of Protection to step into those spheres. He concluded that PN had capacity in all three areas, although, as I've mentioned, he raised concern that it might not be necessary or appropriate to determine the second and third issues about disclosure. The judge noted the need for the court to make decisions that are coherent and that provide clarity for carers and those responsible for acting in P's best interests. And as I've suggested, he observed that rather than seeking to identify yet more kinds of decision-making, it might be simpler and more practical use to focus on the core decision-making areas, but to be astute to applying the principles involved in assessing capacity to the particular individual characteristics and circumstances of the person involved. Now, unfortunately, although he made that observation in that case, the next two cases demonstrate that it wasn't actually quite that simple to step back and try and avoid getting stuck in the weeds, so to speak. In the case of EE was a 31-year-old woman. She had a schizophrenia type disorder and was living in a supported living placement. She wished to become pregnant and to have a baby. Mr. Justice Poole reviewed the expert evidence and the law relating to sexual relations again, and he underlined that the bar for capacity ought not to be set too high by stretching the reasonably foreseeable consequences. So in the case of EE, one concern of the experts was what might happen to EE if she did have a baby, how that would impact on her health. So there was a very significant amount of the evidence that looked quite a long way into the future. And Mr. Justice Poole was keen to focus the experts and the evidence back on the immediate questions that were required to be answered in order to address whether or not she had capacity. And he noted the decision of Bodie J in A local authority and Mrs. A and Mr. A, in which he rejected the local authority's submission that information relevant to the decision to use contraception included foresight of the consequences of bringing up a child. And he warned against blurring the line between capacity and best interests. The judge found EE had capacity to make decisions to engage in sexual relations, although no capacity in relation to contact. And that might seem a surprising conclusion at first, but in essence, it was felt that she was unable to manage those wider capacity decisions on contact. The same had been the case in relation to PN, but that in fact, in the circumstances of a familiar relationship where sexual relations was to be decided, that she would have capacity in those circumstances. So it very much depends on the individual circumstances of P. He concluded also that E had capacity to make decisions on contraception. He did not find it appropriate to determine whether she had capacity to make decisions about conception. And he found it would be an irrational, unnecessary and unjustified interference with EE's Article 8 rights to find that she has no capacity to make decisions about conception on the grounds that she cannot understand, retain or weigh or use that same information. So he was very reluctant to step further into questions that might interfere with the Article 8 rights. And finally, in that triplet of cases I've been discussing, the case of CLF. CLF had a difficult history with many placements and she'd exhibited risk-taking in relation to sexual contact. She was much more settled by the time of this hearing in her current placement, and the court was asked to determine capacity in relation to residence, sexual relations and contraception. Mr. Justice Poole again undertook a review of the case law. He was adding to his observations in PN and EE, again about how the relevant information should be formulated, and I'll allow you to have a look at that, but again, very dependent on EMP's own circumstances. The judge concluded that CLF did not have capacity in relation to residence or contact with others, but CLF did have capacity to decide on sexual relations. And interestingly, he also made an interim finding that CLF lacked capacity in relation to the use of contraception, but that education could lead to her gaining capacity in this area as well. And just to flag here, many of you may have experienced these types of cases because, of course, sexual relations can often come up in the context of young people living in supported living placements where their capacity is evolving, where they may regain capacity. And so this notion that education is central, that care planning may and careful and appropriate care planning with education element can assist P to regain capacity. And some of you may have seen that in your own casework. I have a series of cases relating to procedure. I'm not, in fact, going to run through them for the interest of time, but I will allow you to look at these cases about contempt and print material and transparency. In particular of interest, you may be interested to read the BBC and Cardiff case, where it was found that it wasn't appropriate for the BBC to make a documentary about P. It was simply going to be too intrusive and put his Article 8 rights at risk. Thank you very much.
That's the year in review on personal autonomy, and now we're looking forward. District Judge Anselm Eldergill.
Well, thank you very much for inviting me this evening. And congratulations on winning the legal 500 COP set award.
Thank you.
It was a very kind introduction. I think the last time I had a introduction like that was in Kent a couple of years ago, where the chairperson described me as the outstanding lawyer of his generation and as one of the world's most handsome men. I was chairing the conference myself, so that reduced the effect of those kind remarks. My favourite case in the last 20 years was not the court protection case. It was having Bob Geldof appear before me in a housing benefit claim. Does anybody from the UP here? He wasn't claiming housing benefit himself, but he did appear as a witness, and the state appealed my decision to allow the appeal. They always appealed my decisions because they took the view I was unduly generous, but never with success, I'm delighted to say. But the appeal meant that I had to do a written statement of reasons. And it gave me the chance to write a sentence that I'd always wanted to write, which was, I next heard from a Mr. Robert Geldof, who I understand to be a popular musician. Those famous 1960s statements by a judge about the Beatles originally. But, enjoyed that. So I'm just going to make one or two introductory remarks, then deal with some mental capacity issues, and then some mental health act issues. I quite often start with this slide. I've been doing mental health law for 40 years now. And when I first used to go to the old asylums in the mid-1980s, what you would see if you look at the person with the razor blade there, you go on to the old back wards, the long stay wards, mainly for people with chronic schizophrenia, and you would see a nurse with 4 electric razors in front of him, and he would shave one of the patients, and then he would shave the next one. They'd all be in a queue, and after he'd shaved 4 of them, the razor would be too hot to hold, so he would put it down and he would move to the next electric razor, and he would shave them each in turn, approximately 40 of them. And people 40 years ago on the old back wards weren't considered to have capacity even to be trusted to shave themselves. If you look at the building there, that's Broadmoor Hospital. If you go back 20 years, when they built a halfway hospital, prospect of being discharged was so frightening to a lot of the people in Broadmoor, that eventually they built the halfway hostel 15 yards from the front gate, so that they still had the reassurance of looking at the walls in which they'd been detained. So I always think it's a bit like watching your children grow up. You don't notice the change day by day, but you perhaps put the pencil marks on the wall. That when you look at the pencil marks, things have changed and they've got taller. And progress is frustratingly slow. But in that 40 years, there has been progress. So we've got a mental capacity court now. It has a personal welfare jurisdiction. The court is used. The noticeable change of culture. The LPAs have been a great success. And we do have a dole scheme under the Mental Capacity Act, although it's problematic. So there has been progress, but there's still a lot more to be done. And I want to emphasize that there has been progress, because a lot of what I've got to say is quite critical and might appear to suggest that there hasn't been any progress. I'm going to take my tie off. I put it on to show you respect, but no, I'm not a natural tie worker, and I think 10 minutes respect's enough for anything. Not that sort of society. About 20 years ago, I gave a conference talk. It was actually when the last mental health bill had been published by the government in the mid-2000s, the mid-noughties. And it was quite draconian, community treatment, all this and so forth. I gave a talk at a conference in defense of liberalism. And that's still what I believe in. I'm not talking about liberalism as a political party. I'm talking, people in this room and listening in will have many different political views and support many different parties. Some will be socialist, some green, and some supporters of reform and so forth. But what most people can agree on is that we believe in a liberal democracy. So the democracy bit is that we believe in government according to the will of the people. And the liberal bit is that we agree on the importance of the individual, compared, for example, with authoritarian or totalitarian societies. So I think it was John Stuart Mill who said this, that society is made up of individuals, and each individual has distinctive feelings, personal goals, traits, habits, and experiences. Variety is of the essence of the human race and not a passing condition. Because this is so, most individuals wish to determine and develop their own interests and their own course in life. Now, that's only possible with individual liberty. The existence of a private sphere of action free from public coercion or restraint is indispensable to that minimum independence which everybody needs to develop as an individual. The liberal state accepts that individuals have many different individual beliefs about the meaning and purpose of life, and is pluralistic. So I've personally always been a liberal in that sense. And there's part of me that's a little bit amused when, I mean, those were excellent presentations. 40 years ago, we didn't have that amount of judicial intervention, and we didn't have 40 or 50-page judgments every time somebody wanted to have sex. It was a much more hands-off approach. And that's part of the liberal society, that the state is reluctant and slow to intervene in people's lives and allows them a great deal of discretion about what they do, and allows their families and carers a great deal of freedom of decision making. So I do think, and I'm going to return to this, that we've become too regulatory and too prescriptive. Now, because the principles that I set out there apply to people that we describe as patients and residents, because although we use those terms, they're important individuals, no more, no less than any other individual. Individuals who suffer, who will certain ends for themselves and their loved ones and not others, who wish to develop and be happy and be fulfilled. So although the judge makes orders, in this field, the judge is in another sense their servant, not their master, and it is the judge's duty and the judge's role to seek to enable them to achieve in their life what they want to achieve. And I think these days we've rather forgot that the Mental Capacity Act was designed as an enabling act, an act to help people progress with their lives in the way that they want, rather than to restrain or prevent them from doing so. But I need to move fairly quickly because time is short and I'm not going to speak to all the slides. But moving on to some mental capacity issues, two general observations at the start about the Dole scheme. Until 15 years ago, there was, with a small exception, only one act under which you could be detained on mental health grounds, which was, of course, the Mental Health Act. And that's a risk-based act. So detention or compulsion requires two things: a significant mental disorder and a significant risk. And unless both those things exist, there's no detention and no compulsion. And it doesn't matter whether or not you lack capacity. That's the key thing. So intervention in the lives of people who lacked capacity didn't take place unless those grounds were satisfied. Then, of course, had the introduction of the Mental Capacity Act, which allows for interventions and interference on the basis generally that the person lacks capacity to weigh certain risks or certain information, and that an alternative course to the one that they prefer would be in their best interests. Now, the key thing about this model is that it's really a rather dangerous concept, because underlying it is the idea that we're not actually interfering with the person's freedom to do anything they have capacity to do. It's just that they lack capacity to do this thing for themselves, and we, in our kindness, are therefore doing it for them. But according to this model, they remain just as free as they ever were to do those things they have the capacity to do. And that's in the wrong hands, and maybe in any hands, it's quite a slippery, dangerous game. Now, people have two responses to that, and I'll come to that in a minute. The second general observation is that the Dole scheme involves a lowering of the detention threshold. Because again, subject to one minor exception, you're only liable to being deprived of your liberty under the Mental Capacity Act if you don't meet the criteria for being sectioned under the Mental Health Act. So we have a group of people who are sectionable, and they could be detained under the Mental Health Act. But when the Dole scheme came in, we also have a whole new group of people who don't meet the criteria for being sectioned that can be detained under the. Some people say, well, that's all fine, I don't have a problem with that. It's all positive. They say that in reality, there's no new extra population of people being detained. It's just that we were always detaining these people in the past, but doing so without a legal order. I don't feel that is right. We will never know, because one wouldn't get statistical certainty. But it feels to me, looking at the people I've worked with over 40 years, that this is quite a large number of additional people being detained. And the potential negative is that detention orders don't merely protect vulnerable people, which was Lady Hale's aim. They actually empower the people in whose power the incapacitated person is. And the care home and hospital now have, or think they have, authority to deprive the person of their liberty in all areas of their daily life. Interference with liberty is no longer occasional, guilty, tentative or furtive, but confidently asserted against a person who's incapable of resisting. So I think it's questionable whether this path has been beneficial. And of course, what it's led to is over 300,000 DOLS applications a year. The reason why we've now got several 100,000 applications a year is, of course, Lady Hale's definition of what is a deprivation of liberty in Cheshire West, where she said that whether or not the person objects to the arrangements is not relevant. Now, whatever the answer, that is not the answer. I can assure you of that. The answer I've circulated to you, based on the European jurisprudence, may also not be the answer. But what Lady Hale said is completely at variance with what the judges of the European Court said, which is that whether or not the person objects is relevant, which is what you would expect. So I've given you 3 pages from the book that's coming out. It's too detailed to go into tonight, but we wish to read that and see there an alternative point of view. But just before I move on, very quickly, this is actually where we've arrived at. So, as I say, I started in the mid-1980s, and at that time there was 100,000 mental health beds. That's been reduced to 20,000 now. So we've lost 80,000 hospital beds. And in the mid-1980s, there was 368,000 care home places. There's now 435. So broadly speaking, the beds in hospital have gone down by 80,000 and the care home places have gone up by 80,000. To go with that, there's now 55,000 new applications for detention under the Mental Health Act and over 300,000 under the Mental Capacity Act. What's happening here in the course of my professional lifetime is that we have moved from detention in hospital to detention in community settings. And what I would say is that in many cases, care homes are the new old long stay asylum wards. So one question is this community care? Or is this just moving people from one institution to another? The idea of community care was more individual freedom, more participation in the community, not being detained in an institution. But we've moved from detention in one institution to detention in another. I question whether there's any greater freedom in that arrangement. But very quickly, because time is short, liberty protection safeguards. I'm just you've got the slides, but I'm going to limit it to just 3 points. But the first point, which some of you may have stumbled on, no doubt, is that at the moment, section 16A(1) states that a person cannot be detained under the Mental Capacity Act if they're ineligible, by which is meant the person cannot be detained under the Mental Capacity Act if they meet the criteria for being detained under the Mental Health Act. If you look at Schedule 2, and Parliament missed this, tucked away in Schedule 2 is this provision, the Mental Capacity Act. It's amended as follows: omit section 16A. And the effect of that, it was put in on the slide, is that if this comes in, people can be detained under the Mental Capacity Act, liberty protection safeguards, in preference to using the Mental Health Act. So that's quite a significant change, which I think a lot of people have missed. My second point would be, despite all the work which went into it, this really isn't a simpler scheme. I mean, when you first read it, you think there are 3 conditions for an LPS order, but actually when you read it more carefully, there are 8 conditions. It's actually pretty much exactly the same as the existing scheme. That's the second point. Third point, and the thing that is, I think, really worrying, is that the new Act, instead of eliminating the problem, bakes it into the statutory scheme. So, just to expand on that, if we go back a few years, of course, the problem confronting the government was that lots of people weren't being detained under Mental Capacity Act orders who should be at the benefit of an order. That was the government's thinking. And so they asked the Law Commission to come up with a simpler scheme that local authorities would be more likely to use, and mean that everybody who was detained had the benefit of a legal order and a right of appeal. But actually what this existing Act does is it gets rid of the urgent authorisation procedure and says that even if there isn't an LPS order in place, the detention is lawful as long as it's necessary to prevent a serious deterioration in the person's condition, and the care home reasonably believe that the person lacks capacity. Now, as you know as well as I do, that it can take more than a year for a local authority to get round to doing its DOLS assessments. Sometimes it's taken as much as 5 years. And what this is saying is that that's perfectly legal. It doesn't matter that there's no order, as long as that condition is satisfied. So the way the government has tried to eliminate the problem is by saying that what the courts have always said is unlawful is in fact lawful. You don't need an order for all that time. The courts are never going to wear that. I mean, it's extraordinary for anybody to they would get away with that. Court of protection issues. How long do I have left?
15 minutes.
There are a lot of court protection issues. I'm going to concentrate on 2 or 3 of them. The first is, and it's really the most important issue and the most important problem for the court protection, is participation. Most orders the Court of Protection makes are made on the papers without the judge ever seeing the person. without the person ever being given a proper opportunity to state their view. If you look at the European case law, and it's set out in detail in the book, courts said in countless cases that states must provide adequate safeguards to ensure that individuals are able to participate in the process and that it's sufficiently individualized to meet their unique needs. They must be allowed to participate either in person, through some form of representation, which may require provision of legal aid. Person's participation is necessary not only to enable them to present their own case, but to allow them to have at least a brief visual contact with them, and preferably question them in order to form a personal opinion about their mental capacity. Well, it may happen in some personal welfare cases, but in terms of property and affairs deputyship applications, there are about 30,000 applications a year, and they're just dealt with on the papers. I've set out there different ways of involving the relevant person. Now, the problem is, of course, partly too few judges and relative to the number of applications, which is now getting on for 40,000 applications a year. I find it strange. One of the things that I've been arguing for is that there needs to be a form filed with applications, which is the personal statement form. I mean, I've just put it down there as an Eldergill statement, but it's very strange when you think about it. If any of you who do property and financial affairs, the forms you need to get a deputy order are an application form, the financial statement, so the person's property and income and liabilities, the medical certificate, and the proposed deputy's undertakings. Somehow we've constructed a system where there's not the most important form of all, which is what the person believes. I mean, the Mental Capacity Act says that we make decisions by reference to the person's beliefs and values. So their beliefs and values. The judge or the civil servant who makes the order has no evidence before them as to what the person's beliefs and values are, whether they have any religious requirements about how their money is spent or not used, and so on. So I would urge those of you who are involved in particular in making financial applications to include a statement setting out the person's wishes, feelings, beliefs and values, how they want their property used, how they don't want it used, what their preferences are for their pets and so forth. And that will at least help it to be a more individualized process. Now, the other thing that really surprises me in the 14 years I was in the Court of Protection, and I've been banging on about it for a long time, but with no success, is that after all these years, so it's now 17 years since the Mental Capacity Act came into effect, we don't have any Mental Capacity Act forms in any language other than English. No advice leaflets published by the court in languages other than English. There's no monitoring of the take-up of the Court of Protection service by different cultural groups. I get the impression, but it can only be an impression, that some groups in society prefer not to come to the Court of Protection. That's just an impression. But clearly we're not making it accessible to all sections of society. Now, a huge problem with the Court of Protection is legal formalism. So if you look there, that wafer thin document, which is about the width, a little bit more than the width of a fingernail, is the original act, original Mental Capacity Act. A lot of us went to a lot of effort to keep it simple, because it has to be understood and used by people with marginal capacity, often their families. In the hands of us lawyers, that has ballooned into a blue book, which is 3,000 pages long. Every month, 39 Essex summary cases, there's about 60 or 70 pages. There's the Act, rules, regulations, practice directions. The Rules Committee is pretty much committee in perpetual motion. The answer to everything is to issue yet more forms and practice directions. All of those take time to fill out. And if you're asking a lawyer to do it for you, it becomes an incredibly expensive business. I mean, I've seen cases where the legal costs can be well into 6 figures. That's not an acceptable service. I mean, courts need to make quick decisions using simple procedures. The capacity threshold, people who apply for financial deputyship now have to set out on the form what they consider the person needs to be able to understand in order to have financial capacity. So it's against this checklist that the person's capacity is assessed. That's one example that I saw this year. I don't understand most of that. I certainly don't do it, and too much, isn't it? If you've got to understand all that to be considered to have financial capacity, there's going to be a great many people who fail tests, who their family and neighbours would quite reasonably think have sufficient capacity to get by. Another problem with this legal formality, all judges have their own style. I mean, Denzel Lush, the last senior judge, he was very laid back and relaxed. Judge Hilda is much more procedural. I think that would be fair to say. There may be benefits for that approach, but it does also come with a clear disadvantage. So if you look at that chart, the actual number of final orders made by the Court of Protection is almost exactly the same now as it was in 2017. The number of orders we make has increased by 16,766 per year. So we're not making any more final orders, but there's this incredible judicial interventionism where everything has to be set out in an order. You can't just drop somebody an email and say, you forgot to put this bit of information in, could we please have it? You have to stay the proceedings and issue an order saying that they'll be struck out if they don't provide the information, which is to be provided in a formal statement on a COP24 and an application to lift the stay made on COP9 form. Now, it takes the court 3 months to issue that order. And then even if the person responds within a week, let's say, it will take them 3 months to read the statement. So you've lost 6 months, and it's not surprising that many applications for deputyship are taking more than a year to conclude. So again, we need to go back more to the system. I've put in the next slide some alternatives to how we do it. I think there's a good argument for a mental health court, which is much less formal. There's a good argument for taking away the Court of Protection's non-contentious work and giving it to the public guardian to do, so that the Court of Protection simply deals with contentious cases. It's an outstanding argument for having some lawyers in-house. I mean, Erwin Mitchell or the public guardian or the official solicitor would never think of case managing 40,000 applications and files a year without a lawyer in the building. It's very strange. So I've given you 30 pointers there as to how I think the Court of Protection could improve the service that it gives. I'm going to just finish with 1 or 2 points. The Mental Health Act. So we've got the Mental Health Bill. Just going to pick 1 or 2 things. We need to redo that, I think. It's too limited. Doesn't do anything about the problem of all the people detained in care homes. It doesn't do anything about the problem of the overrepresentation of Black people in the Mental Health Act compulsory procedure. So people classified as Black Britons are 10 times more likely than white Britons to be placed under a community treatment order. That just cannot be right, and it cannot be defended. And it's very tempting to say to the doctors, if you can't play with the scissors nicely, they're going to have to be taken away from you, because that's just unacceptable, particularly when you realise that people in the community are not considered to be sufficiently dangerous, need detention in hospital. Black Britons are 4 times more likely to be detained in hospital. The bill says absolutely nothing about that. And it says nothing about a lot of other things. There's nothing about seclusion. There's nothing about restraint. Waters down the powers of spouses and partners. Doesn't deal with obvious grafting omissions. Doesn't have anything to say about all the people with mental illness in prison. It doesn't reintroduce a Mental Health Act Commission to protect people who are subject to compulsion. Doesn't have anything to say about children and the complicated interrelationship of various acts. Doesn't clarify common law powers. And lastly, and I'll finish there, doesn't have anything to say about rehabilitation. So if you go back to the Northern Irish legislation in 1986, there were rehabilitation provisions. And obviously when people have been detained and they're leaving hospital and they're picking up the pieces, you need proper rehabilitation in terms of job opportunities, training, and so forth. So a lot needs to change. My feeling is, to sum it up, we don't want the government to proceed with the current mental health bill or with the liberty protection safeguards. What we need is a commission or committee made up of experts, by which I mean people like on the front line and from the other professions who actually deal with these problems day to day. And we want a single act that actually covers both Mental Health Act and Mental Capacity Act issues. Thanks very much.
Thank you very much. Told you it'd be thought-provoking. So the challenge now is thoughts about a single act bringing together mental health and mental capacity. And I am glad you finished with the slide on opportunity, because it was beginning to get really depressing. And you wanted to cheer us up with the last slide. Yes.
I mean, the 1983 Act is the same structure as the 1959 Act. That's the year I was born. I'm collecting my pension now. There's not been new thinking since the 1950s. And surely we don't need another amending act, bits of tweaks. We need a fresh thing based on how society has changed in those 65 years.
Questions? And please direct them at the relevant speaker. Oh, we've stunned you into silence. Is there?
Somebody must have thought that was all cobblers.
I've got 2 questions, but there may not be time to answer 2 questions for me, so fair enough if there isn't. The first one is, you were referring to the detention of people in the community as opposed to in institutions.
Yes.
And that the MCA is used in order to enable that to happen.
Yes.
Being detained, but else not where they were detained previously. What were your thoughts about the fact that detention is variable in terms of how restrictive it is?
Detention is,
In terms of how restrictive detention is, it varies.
yes,
And so a lot of situations of people living in the community are very different to living in an institution.
yeah,
That might be considered to be a positive development because although a person is still detained, they're living in supported living and they're able to go out and about and within
yeah,
a detention
yeah,
framework, but it's a very different scenario.
yeah,
And that move from institutions to the community, well, not always, but generally is a good thing, is one view. You appeared not to think that that was the case, but I may have understood there's probably a more greater nuance in what you're saying. That's the first question. And the second one is with regards to the terrible disproportionality that there is of the way that you say that certain groups are treated in the mental health system on grounds of race. Do you have any thoughts as to what is the way forward specifically in that regard, whether it's to do with the doctor end of things or whether it's further down the line that there needs to be some sort of intervention and legislative framework that tackles that awful picture we have currently?
well, there's definitely no easy solution, but just taking your first point about community detention. You're talking about, I mean, there were lots of people in group homes and supported living in the 1980s. People obviously living in their own homes. Well, so I am sceptical that there hasn't been any significant increase in freedom. I think to me, and I've missed out some slides, I think it's fairly clear that we live in a much more risk-averse, legally regulated society than we did in the 1980s. People have become very pessimistic. So I don't see much of that additional freedom that we all hoped we would see in the 1980s and which we did see in the 1980s. In terms of the number of Black people subject to compulsion, I think you have to get rid of community treatment orders. You can't allow, you can't have orders that are applied in that disproportionate manner. So I think community treatment orders have to go. We can all debate as to exactly why they're disproportionately used to such an extent. But the key thing is they are used 10 times more for Black people, and that has to stop. You just have to say that's not a system that is acceptable. In terms of the fact that 4 times as many Black people are detained, I would expect more Black people to be detained because but not to that extent. But I mean, all the evidence suggests that the effect of racism in society is that you have fewer employment opportunities, worse housing, worse educational opportunities. All those things lead to stress, mental stress, and are a breeding ground for distress and mental health issues. So I don't think there's any human being on the earth who doesn't experience the negative effect of poor housing, economic poverty, and so forth. So that's going to take a massive effort by government to address that sort of social exclusion. In terms of the Mental Health Act, I think maybe you have to give people who are sectioned the right to nominate somebody from their own cultural background to give a third medical recommendation for detention. So in other words, there's the normal procedure, 2 doctors and essentially a social worker. If the person feels that, or their lawyer feels that the evidence is insufficient, there'll be a panel of psychiatrists from each different cultural background that you can ask rather than a third medical opinion.
And would that overcome, do you think, the additional implication, which you didn't refer to, besides the fact that racism is bad for people, the additional implication of unconsciousness by predominantly white doctors?
I don't, you can't totally get over, you certainly can't get over unconscious bias.
No.
But all of us have a bias, whether we're conscious of it or not. I mean, what will have come out in my book is that I have a strong preference, but bias would be another word, for liberty and discharging people. You know, there are, if you look at the discharge rates of different judges, I mean, I think mine would be 60 or 70% in terms of lifting Dole's orders. I think other judges it might be nearer 5%. I mean, you would know better than me, but one of the problems with best interests is the 2 words are virtually meaningless, aren't they? I mean, we could go round this room. I could give you a simple scenario of half a page and ask you to say what's in the person's best interest, and we'd have 40 different answers, I think. So it allows the judge a lot of discretion.
Yes, certainly.
Yeah.
And practitioners know that. Anyone else? Yes.
Can the government override like the European Union that the European Court of Human Rights? Maybe someone brings a case to the Court of Justice or whatever, and the government give it a final judgment. The person took it to the European Court of Human Rights, and if the European Court of Human Rights pass a judgment, can the government still say no to that kind of?
Well,
Just before you answer that, do we know if everybody watching is able to hear comments from the floor?
They should do.
Yes, okay. So we don't need to repeat the question again.
could you repeat it? I mean, I'm 30% deaf, so.
I think this is right. If the European Court of Human Rights makes a decision, does the government have to implement it, or can they refuse to implement it? Right, isn't it?
Yeah. Well, I mean, it depends on the area.
Okay.
Okay.
Because it was time to finish at 7:30. Yes.
Well,
So if you.
So if you take the Dole scheme, we had the Bournemouth case in 2004, where the European Court set out very precisely what's required in terms of deprivation of liberty orders. And what's that, 20 years later, we're still waiting for the suitable scheme to be carried into effect. So I think in practice it is possible for a government drag its heels and not fund what is necessary. I think the courts ought to have been a lot tougher with the government than they have.
And of course, as a matter of law, the straight answer is that no, the government doesn't have to implement. And the famous example is prisoners' voting rights, where the Court of Human Rights has said several times now that prisoners should have the right to vote, and the government has not just not implemented it, but made a point of saying we are not going to implement it. I don't know off the top of my head whether that's going to change with the government, but that's somewhat off the question, off the topic anyway. We said we would finish 7:30. Any more questions from the floor here? Yes, Nicola.
It was a comment really,
Yes,
which
it is.
going back to the 1980s, which is when I started doing mental health and review tribunals and homelessness, and then through the early 1990s with the NHS and Community Care Act, that was seen as the flagship piece of legislation for assessing people's needs and meeting their needs as individuals. And I think what we've ended up with is large groups of people being deprived of their liberty, as you say, in care homes, which are the new replacement for the old asylums. But we're missing the individual. We're always missing the person at the centre of what should be at the centre of our attention.
Yeah, I agree.
Wondering what you substitute for the regime for where clearly there is a lack of capacity, but we will discuss that downstairs over some food and drink, so please do join us for that. But before you do that, please join me in expressing appreciation